Mr. Logan, this is very serious business. This is essentially a homicide case. The maximum punishment is up to life imprisonment. And the facts are terrible. The closer you look at it, the worse it gets. Count one is operating with a suspended, revoked, or denied driver's license causing a death. It's alleged that on December 2nd in a snowstorm that you were driving with a suspended license, and by the operation of that vehicle did cause the death of a young man named Anthony Miller. Second count, you were operating the vehicle without any insurance. We get lots of people doing both of those things, driving suspended and driving without insurance. When there's a death, it becomes a felony, punishable by up to 15 years in prison and a fine of up to $10,000. You're also charged as a fourth habitual offender, making it theoretically punishable by up to life imprisonment. You were arraigned on that charge, and bond was set by me in the amount of, I believe it was $75,000 cash or surety.
I think it was 100,000.
100,000. Yes, there it is, 100,000 right in front of me. I ordered that you not use any drugs or alcohol. I ordered that you possess no weapons or firearms, no assaultive behavior, wear a GPS monitor, and no driving. I also ordered that you must report to the day reporting center on the very next day and sign the condition to agree for testing. So you did. I believe you're on the GPS monitor now, and you signed that on December 3rd. You and I were, I think, over the Zoom feed. I appointed Attorney Ross Truckee to represent you, and there were records made at that time that I set the bond about some previous fails to appear, possible case out in California, a driving suspended ticket in Kalamazoo from November. So bond was set in the substantial amount of $100,000. Pre-exam conference was originally set for an earlier date. It's presently set for January 7th, which is my day. As I indicated, Mr. Truckee was counsel at that time. There was discussion that you were in discussion with the Levine and Levine law firm, the Marcoux law firm, and that you were going to be retaining Anastasi Marcoux, and he's here with you today. Sometime last week, I think this substitution was executed. It hadn't made it to the file at the time I dealt with this last week. There was a notice that we received on Monday, December 16th from the Day Reporting Center. It was Monday, December 16th with the date of the test. It was filed with the court on December 20. Well, it was filed with somebody, I guess us, on December 21st. December 21st was Saturday. So I don't know when we saw it. We first saw it on the 23rd. Ms. Davis saw it, and she moved to cancel your bond. She filed a written motion to cancel the bond, indicating that you should show cause why you should not be brought before the court for bond violation. The test.
The test was on the 16th.
16th.
The notice of the results was received on Thursday, the 19th.
All right, the one we had has a date of the 21st on it, which is a Saturday. You might have got it before we did.
That's, I think, when Pam from DRC emailed it to everybody was on Saturday. I had gotten it from them on Thursday prior to them filing that motion.
I think that's correct. The test printed result is from the 19th. However, the test is from the 16th. I don't know when either the prosecutor or the court received those results.
Right. Now, we had a very short notice emergency hearing on Friday afternoon or Monday, the 23rd, the last day before the Christmas holiday.
Typically, that was on the 19th.
No, it was the 23rd. No, you're right. It was, let me look at my note here. It was on the 20th.
Yeah, that Friday.
Friday, not the Friday. I wasn't here Monday. It was Friday. It just felt like the last day because it was my last day. So we had an emergency hearing, show cause why bond should not be revoked. Notice was not given. They attempted to, but Mr. Thomas wasn't here. Mr. Marcoux wasn't here. And Mr. Truckee wasn't here, and neither was the public defender. I learned that a substitution was forthcoming, and Ms. Davis cited the court rule that allows the court to do a bond violation. I was not clear, and still wasn't clear, what my authority was to immediately revoke bond without any sort of hearing or due process. So I set the matter for hearing this morning. Ms. Davis represented at that earlier hearing that the laboratory reports have come back regarding the defendant's drug and alcohol tests at the time of the accident, and that they intended to be amending the charges. The petition to revoke the bond and the motion to cancel bond states, and on 12/19, the prosecutor received the MSP lab report. Now, that would be for the actual driving, indicating the defendant at the time of the accident was positive for methamphetamine, fentanyl, and morphine, as well as amphetamines. They also allege that you have 3 previous operating while intoxicated convictions, and that on the 19th, the results were received back from the Day Reporting Center that you tested positive for methamphetamine and amphetamines on December 19th. Ms. Davis obviously was not very happy about that. Frankly, neither was I. And she asked me to revoke your bond. And is that still your request here, Ms. Davis?
Yes, Your Honor. Just to kind of clarify, bring the court up to speed too. We haven't amended yet because we're waiting for the computer crimes unit from MSP to give us the report on the telephone usage, which could end up resulting in an additional charge of reckless driving causing death. So at least the amendment now that we know will be happening is OWI causing death, which is a 15-year as a habitual fourth, and OWI third, which would be a lesser included, depending on how that comes out, which is a 5-year, but also a habitual fourth. With the bond conditions that have been in place, it's my understanding from Attorney Marcoux that defendant has not been tested since the 16th. And so I guess part of our discussion prior to the hearing was, I'd like to have him test right now. And if it's a positive, then I would still be asking for his bond to be canceled. And if he passes it, I would leave it to the court's discretion as far as a punishment or some sort of repercussions for the use of illegal substances while on bond. Obviously not immune to the idea that, with a recovery and relapse do happen, but this is a very serious situation. And Your Honor was obviously less concerned about the use because he wasn't driving, but we can't guarantee that he's not driving. We do have the GPS tether on him, which has been effective, and so we can kind of keep an eye on where he's going, but we really would like to get a handle on this substance issue. I also, in the emails with Pam from DRC, trying to get a handle on how they're doing the testing and what they're testing for, they are not testing for all of the substances that he was positive for at the time of the crash. So the test that they're using will not detect, I believe, fentanyl and maybe morphine. So they can do a 14-panel instant test. They typically only do the 5-panel, and then the alcohol test. I would ask that the court amend the bond conditions if he is going to remain out on bond, that he be required to do the 14-panel instant test and the alcohol test, and that it be on a regular instead of the random call-in, basically no less than 3 times a week, because these types of substances will typically remain in a system for up to 72 hours. If we do the 3 times a week testing, we should be able to monitor it pretty safely. So with that, I leave it to the court's discretion. Thank you.
All right, before you speak, Mr. Marker, let me say one more thing. One of the concerns I had is that you were in custody from December 2nd. You posted bond on December 13th. So you were in custody for 11 days. The test that was positive was on December 16th. So it would be 5 days after you got out of jail, you tested positive for methamphetamine. Let me look at it again. And amphetamine, I think. I keep having trouble finding that DRC file. Now, that isn't evidence at this point. And the concern was that there's no testimony or evidence regarding that, but based on our knowledge from dealing with these sorts of things on a daily basis, methamphetamine doesn't stay in your system for 15 days. So the obvious concern was, and my concern and Mrs. Davis's concern, as you got out of jail after 11.
A routine bond review quickly turned into one of the most intense hearings in the courtroom. Judge Logan Thomas faced allegations far more serious than a typical bond violation. Prosecutors argued that the defendant, already charged in a fatal crash while driving with a suspended license, had tested positive for methamphetamine just days after being released from jail. With the possibility of life imprisonment hanging over the case, every decision carried enormous weight.
Clean days and immediately relapsed. What you're charged with is driving suspended with a death, which is a 15-year felony. As a habitual felon, makes it punishable by up to life imprisonment. In my mind, it's worse if you're intoxicated or under the influence of drugs causing a death, but it's the same offense. It's a 15-year felony. The time I set your bond, I didn't know whether you had alcohol or methamphetamine or, heaven forbid, fentanyl in your system. So the concern is that between the time you got out and the time you tested 5 days later, you'd started using again. And that is our concern. Mr. Marcoux?
Your Honor, I would ask the court to consider following the, for want of a better phrase, game plan that Ms. Davis outlined for the court. He's ready, willing, and able to test right now. I am optimistic he'll test negative for all controlled substances. If he does not, then I understand the court's decision to revoke and Ms. Davis's request to revoke. He has been attending AA, NA. I have proof of that. He has been calling the day reporting center every day since then to be able to test, but for whatever reason, because it's random, his name has not come up. I've also confirmed that in fact, he has not been driving to work. He's been getting rides from co-workers and otherwise. So I would ask the court to consider that particular plan. And obviously, what I told him this morning was if the court were to give him any consideration and not revoke bond, that he would have to test more frequently. The test would be a broader spectrum than it currently is. And that if he doesn't test positive, or is found driving, that at that point, the expectation would be that his bond would be revoked no matter what. There wouldn't be much argument on either way. So that is my proposal at this point. He understands that there has to be a short sanction. My concern, Your Honor, and it's not, I don't know if it's a legal argument, I don't know exactly how to phrase this, but it's disturbing that somebody signs a bond condition that talks about testing positive. You get 24 hours, 48 hours. It almost gives a sense of like I don't want to say a pass, but it basically gives somebody notice that this is what's going to happen to you if you test positive. And unfortunately, it can possibly create a risk that somebody thinks that's all that's going to happen to them.
Well, that's an old form.
Yeah, and I think we need a new form on this case.
And it doesn't have any due process, if there's a problem with the test. Well, first of all, let's see whether we've got somebody to do an instant test. All right, we've got somebody that can do an instant test on Thomas Logan. That's fine. It's casual post-Christmas, but so are Dan or Matt there? How are you going to do it? That's for fentanyl and methamphetamine. All right, well, let's try that. All right, thank you. All right, bye. All right.
Your Honor, just
Yes.
to clarify, what is the level of testing that we have here? Is it
Well,
just
all we have
5?
right now are the instant tests. If you want him to go to the day reporting center and come back, we're going to sit here for an hour.
No, and I guess what my thought was is we do whatever instant test we have here,
Mhm.
assuming that is negative for substances. I would still ask that he go and test at DRC with a 14 panel
Okay,
today so that we can get him on a more regular schedule.
all right.
Thank you.
Mr. Logan, this is very serious business. This is essentially a homicide case. The maximum punishment is up to life imprisonment. And the facts are terrible. The closer you look at it, the worse it gets. There's a lot of public interest. There are a lot of families that have interest in this. Everybody at the school, everybody in the neighborhood. And so the feeling is if you're going to be out on a substantial bond and just using meth, we might as well just cancel your bond and let you sit. When bond is canceled, in theory, the prosecutor has to bring the case to trial within 90 days or a bond needs to be set. General rule in a felony case is if the defendant's unable to post bond after 180 days, they're entitled to have a bond set. If bond is denied, you're entitled to either have a bond set or have the matter tried within 90 days. When I was prosecutor, I used to welcome it. I said, yeah, we'll try this in 90 days. But it's not always possible in this kind of case. They're awaiting laboratory reports regarding substance abuse. They're awaiting probably autopsy reports, accident reconstruction reports. These kinds of cases can take time. And because of the seriousness of it, the prosecutor charged this most apparent offense, driving with a suspended license, immediately, thinking they'd wait until the other stuff comes back. So I'm going to send you out with Ms. Kiefer from the probation department. We'll do an instant test. Your test for methamphetamine is going to be negative. Is that correct?
Yes, sir.
When did you learn that your test was positive?
Thursday, I believe, last week.
Right now,
As the hearing unfolded, the judge carefully reviewed the timeline. Prosecutors explained that new laboratory evidence suggested the defendant had multiple controlled substances in his system at the time of the deadly crash, including methamphetamine, fentanyl, and morphine. They also revealed that additional charges, including operating while intoxicated causing death, could soon be filed. Concerned that the defendant had allegedly relapsed only days after posting bond, the prosecution asked the court to revoke his release and send him back to jail while the case moved forward.
I'll just leave it at that. The last thing you need in your life right now is methamphetamine, closely followed by fentanyl. That's a fairly recent phenomenon where they're combining a powerful stimulant like methamphetamine and a very powerful depressant like fentanyl. That's why we have so many people dying. All right, I'll suspend the record here for a moment. You go. All right, we are back on the record. Ms. Kiefer, thank you for your help. How did we do with the instant test?
He was negative.
All right, very good. That test for alcohol and or
It
methamphetamine?
does not test for alcohol, it does not test for fentanyl, but it does test for everything else.
Test for morphine?
No, well, it will test for benzodiazepines, it'll test for cocaine, methamphetamine, marijuana, amphetamines. It is a 10 panel, but it is not the extensive because fentanyl is a bigger test.
All right, thank you. All right. So that's positive news. All right, Ms. Davis, in light of that new information, what's your position?
Your Honor, as I had stated to the court before, if he tested negative on the instant test, I would still like him to complete a 14 panel at DRC today. And I still believe that there should be some sort of a sanction for what has occurred. This is not just a minor bond violation. This is use of a controlled substance, which is a felony, a 10-year felony for possession of methamphetamine. So with that, I would ask the court to impose some sort of a sanction against him for this positive test, which was lab confirmed. It does seem that from DRC's information to me, they did not tell him on Monday, the 16th, that his test was a presumptive positive, that they instead just simply sent it to the lab and then intended to discuss it with him sometime this week when he came in to test again. That's something that I'm going to address with DRC so that we can maybe have a better process on this.
Well, yeah, they don't always know, and sometimes, very often, they wait for lab confirmation, which certainly delays things.
Right. So with that, I think to the court's discretion at this point. Obviously, if there is a positive on the 14 panel or any positives coming up in the testing, then we'd be seeking to cancel his bond. Thank you.
All right, well, okay, I don't have a problem with that. The problem is they're very expensive, like $45 a test.
I believe that's 45 for either one of the ones that DRC is using right now.
And so right now, the bond just left it randomly, and they did it randomly. 3 times a week would be about $150 a week for the next many weeks pending circuit court. So that is an issue. But Mr. Logan, you're still employed, correct?
Yes, Your Honor.
Now, my recollection was that you live near Vicksburg. Where do you live?
Well, that house was broken into by people while I was in jail and demolished. So right now I'm residing between my grandfather's old house that passed and my buddy Tom's because my ride.
Which is where?
Galesburg and Climax.
All right, so so it's a long way from Galesburg to Sturgis.
Yeah, I mean, I used to drive it all the time. Now I just have to get a ride.
We haven't had a valid license in years. You've been revoked for 5 years, but to get a ride, it's 50 miles from Galesburg to Sturgis. But I have not received any information that you've been driving, and I think if you pulled up at your shop driving, the guys at the shop would rat you out.
Yeah, I would never.
So I don't have any information that you've been driving, but just the logistics of getting from where you live to where you work and testing in the meantime is daunting. So there's a significant difference between canceling your bond and ordering a sanction for a positive test. We order people not use drugs or alcohol every day, knowing that they're going to have a difficult time complying with those terms. People that are addicted to methamphetamine don't just stop using methamphetamine because the judge tells them not to. When I have a person that's on bond on a methamphetamine case, and I have a condition that says you don't use bond until I see you next time, it's like saying, hold your breath till I see you next Wednesday and don't breathe again until then. You have a very strong, powerful addiction. And I didn't know that there was a methamphetamine and or fentanyl component to this until I got Ms. Davis's motion. The charge was driving suspended with a death. There may have been some suspicions, and they called our office that morning for search warrants. And so my staff was dealing with it. And now I find that after doing 11 days in jail, within a few days upon your release, you tested positive. And that was on the 16th. Now it's 10 days later and you're negative. So we've got a baseline that you're negative. And I'm assuming you're going to be negative for fentanyl and any other substances as well. This bond condition says no drugs. Drugs like alcohol are legal. Drugs like marijuana are legal. It's legal in Michigan for people to use marijuana if they're an adult for recreational purposes. Not while you're on bond. You can't use marijuana. You can't drink alcohol. You can't take any controlled substance unless it's prescribed by a doctor. You are presumed to be innocent until the state is able to prove otherwise, but you've been charged with a very serious crime. You're also presumed to be entitled to a bond. Under very limited circumstances, the judge have authority to do no bond. But there is an allegation that you violated the condition of your bond by using methamphetamine after you're released from custody. Mr. Marcoux, is your client prepared to speak to that?
Your Honor, I think because of the nature of the underlying criminal cases and the nature of the allegations and the similarity between the two, I think
The defense urged the judge to take a different approach. Attorney Anastasia Maru argued that his client had been attending recovery meetings, had not been driving, and was willing to submit to immediate drug testing in court. The judge agreed to pause the proceedings and ordered an instant drug test. Everyone waited anxiously as the results came back. The test was negative for methamphetamine and several other substances, giving the defense a much-needed break. Even so, the judge made it clear that the earlier confirmed positive test remained a serious violation of the court's trust. The defendant entered a no-contest plea to the bond violation, allowing the court to move forward without admitting or denying the allegation.
Mr. Thomas would be more than willing to do a no contest plea to the bond violation. I just don't want him saying anything else otherwise because of the similarity in the substances that are alleged. And if the court is willing to accept that, then we can move forward with the bond violation issue.
All right. Mr. Thomas, there's an allegation that you violated your bond by using a controlled substance, specifically methamphetamine. You have a right to have a hearing on that where the prosecution must establish, at least beyond a preponderance, that you use a controlled substance in violation of the court order. You could plead guilty to that, or you could also plead no contest. By pleading no contest, you don't admit what happened. You also don't deny what happened. And I would use the laboratory report from the day reporting center as evidence that you were positive for methamphetamine. Are you willing to plead no contest to that charge?
Yes, Your Honor.
All right. I'll accept that and use the lab report for the factual basis. What's your work status right now? Are you shut down between Christmas and?
No, I worked yesterday. I worked 7 days a week. I work New Year's.
You work Christmas Day?
Yeah, it's livestock, so they don't know it's a holiday.
A good point. I didn't realize that was what do you do?
I'm a manager for a pig farm.
How many different pig farms do you manage?
Well, we had to do a test because someone messed up at one of the ones while I was gone and broke biosecurity, but 2.
Where are those farms?
One of them's on Notable Road and one of them's on Featherstone.
For some reason, I thought it was a manufacturing plant. Yeah, cows and pigs don't take Christmas off. The dairy farmers are 24/7, 365. Let's talk for a minute about what our plan is for January 7th. That would be the pre-exam conference. And I presume by that time, the amended complaint will be filed.
Yes, at least as to the OWI portion. It just depends on what comes back from CCU and the accident reconstruction report, if there is going to be a reckless causing death, but
Well, that could take
it could
weeks and
take,
weeks and
yes.
weeks.
So I've at least discussed that with Attorney Marcoux, so he's aware.
Well, they're all the same maximum punishment, 15 years as a habitual. In my mind, obviously operating while intoxicated with a death is a more serious charge than operating while suspended with a death. But and then reckless, in order to prove that you're operating while intoxicated, they'd have to prove that you were intoxicated or at least impaired by the controlled substance. The fact that there's a controlled substance in your system doesn't necessarily establish that you were intoxicated by it. And I don't yet know what those results are. But you've got competent counsel. The prosecutor is all over this. She was on it from the first day, fortunately. And so we'll see. I'll be the judge that will be shepherding this forward. I believe January 7th is
The conference date, Your Honor?
pre-exam date.
And when is the exam?
Theoretically, it would be January the 14th at 1.
Okay, understood.
All right. Now, you dodged a bullet in that your bond isn't canceled, but you got weaned because you're going to jail for 24 hours starting right now. Someone's going to have to tend the pigs. 1 day credit 0 for your bond violation, leaving 1 day to serve. I didn't want to set up a weekend. The jail isn't accepting weekends. There should be some immediate sanction for this. So the next one could very well result in the revocation of your bond. All right. I'm also going to amend the bond that you need at least 2 14-panel tests per week. And I will see everybody on January the 7th.
Thank you, Your Honor.
Your Honor, I am triple booked on the 7th. I believe that Ms. Davis and I can conduct a conference by phone or otherwise. In the meantime, I'm expecting that.
I'll be fine. You have both got, to your defense, you just got in it.
I've gotten the reports. The prosecutor sent me everything last week. I've already started reviewing them. I'm thinking about, what we might be doing moving forward. Ms. Davis will communicate the offer to me before or around the 7th, and then we'll decide whether or not we'll have a hearing on the 14th.
Very good. Thank you.
Thank you, Your Honor.
Although the instant test prevented the immediate cancellation of bond, the judge warned that the defendant had narrowly avoided a much harsher outcome. Instead of revoking his release, the court imposed a 24-hour jail sanction and ordered far stricter bond conditions, including frequent 14-panel drug testing each week. The judge emphasized that the case was essentially a homicide investigation with devastating consequences for the victim's family and the community. He reminded the defendant that any future violation could result in bond revocation and a return to jail until trial. As prosecutors continued gathering evidence, including accident reconstruction reports and cell phone records, the courtroom was left anticipating the next hearing, where even more serious charges could be added.